Why would the US Secretary of State Marco Rubio want to dismantle the International Criminal Court?
Now, many of us don't know too much about what the ICC is and what it does. But according to Rubio and his State Department, the court currently poses an existential threat to US security and sovereignty.
But here's the thing. The US isn't even a member of the ICC. So what has Rubio got to worry about?
From the BBC, I'm Tristan Redman in London.
And I'm Katrina Perry in Washington, D.C. Welcome to The Global Story on YouTube.
Katrina, thank you so much for stepping in to cover Asma when she takes some well-deserved vacation. Many of our viewers, loyal viewers on the BBC News channel already know you very well. But for listeners of this show who may not know you so well, tell us who you are.
Thanks for having me, Tristan. Trying to fill in for the great Asma while she's on holidays. I'm based here in Washington, D.C. and as you say, I'm chief presenter on the BBC News channel, so listeners may know me from that. And I also host the BBC podcast, The President's Path. So when listeners are finished enjoying this one, they can head over there and check that one out.
Well, we have for our listeners today a conversation that Katrina and I have had with Philippe Sands. Now, Philippe Sands is a human rights lawyer. He's an international law professor and a writer, and he's someone with a particular point of view on international courts. He's been a participant at many of them, representing, for instance, countries like the Gambia, Palestine, Mauritius, and other nations at various international tribunals.
Yes, such an interesting man. And he says to understand the State Department's latest plan to dismantle the ICC, what it's thinking about, what its motivations are, you really have to go back to the beginning.
Well, just in terms of history, modern international criminal law begins really in 1945, when three global leaders, Franklin Roosevelt, Winston Churchill, and Joseph Stalin, got together at Yalta and decided they would not line up the Nazis and execute them, but rather create the International Military Tribunal for Nuremberg. And with that was born in the autumn of 1945, the world's first ever international criminal tribunal. That delivered its judgment in the autumn of 1946. And then nothing much happened for 50 years until we got the crimes of the former Yugoslavia and Rwanda when the Security Council, led by the United States, Madeleine Albright in particular, to give her credit, created two new international tribunals. And that catalyzed an effort that had been going on for nearly 50 years to create a permanent standing international criminal court. And the negotiations began in 1994, and they finally concluded in July 1998, at a meeting in Rome. I participated in those negotiations in Rome, and there was then adopted the statute of the International Criminal Court, which came into force 4 years later in 2002.
In those negotiations, was there a debate going on about just the level of power that should be given to the court, how far-reaching or otherwise that should be?
Yeah. So basically what happened in the negotiations was that the drafters, the negotiators, agreed that the tribunal would have jurisdiction over four international crimes: war crimes, methods and means of warfare; crimes against humanity, the targeting of individuals; and genocide, the targeting of groups. They'd also be given jurisdiction, but only exercisable at a later date, on a fourth crime, the crime of aggression. So the power that was given to the court was limited to these four international crimes, and it was limited to very specific situations. The conduct which is alleged to be a crime must either take place in the territory of a state party, or it must be perpetrated by the national of a state party, or it must be referred to the International Criminal Court by the Security Council. And absent those three situations, basically the court won't have jurisdiction. So it was very narrowly constrained. And what that meant was that if a state chose not to become a party to the Statute of Rome, as it's called, they could not be subject to the jurisdiction of the court in terms of crimes committed on their territory. But we'll come back in due course to what happens if a national of a non-state party commits a crime on the territory of a state party.
And Philippe, you're not simply an observer of the court. As you mentioned, you've been an actor in its establishment. Can you just lay out for us what your involvement with the court's been?
So, I teach international law, and so for years, and beginning in particular at the time of the Yugoslav and Rwanda crimes, I became involved in international criminal law. I'm not a criminal lawyer, I'm an international lawyer. That then caused me to be asked by a group of Pacific Island states to join their delegation in the negotiations at Rome. And in fact, so what happened was the Pacific Island states, they're very small and they're not powerful actors, should we say, but they have ideas and they have the right to participate. They were given the task of drafting the preamble to the statute of the International Criminal Court, and that task was then allocated to me and to my colleague from the University of Geneva, from the Graduate Institute in Geneva, Andrew Clapham, and we did the first draft of the preamble. And we assumed that the bigger countries would, review our preamble and take out any things they didn't like, but they never did that. And so the preamble sort of passed under the radar and was approved pretty much as we drafted it.
Let's just explain, first of all, because a lot of these acronyms can be confusing. We're talking about the International Criminal Court, which is different to the International Court of Justice, of course. The International Criminal Court is, as you've outlined there, about prosecuting individuals who are accused of very serious crimes. The International Court of Justice is about disputes between countries. But a key part about the ICC is, in a way, not the countries who've signed up to it, but the countries who haven't. Many of them incredibly powerful nations. China, Russia, North Korea, Turkey, Israel, and of course, the United States. Why is the US not a member of the International Criminal Court?
The US is not a member of the International Criminal Court because I think any president who is inclined to support it knows that they would never get through the US Senate a ratification of the statute. And so no president has proposed it. When it was adopted in 1998, the United States played a very active part in its negotiation. And so they fashioned a statute that was the most acceptable, I suppose, to the president at the time, that was Bill Clinton. In fact, a few months afterwards, Bill Clinton attended a seminar at New York University, and I happened to be there. And at the reception afterwards, I did ask him what his concerns were with the statute of the International Criminal Court, and it was really rather remarkable. He knew particular provisions by heart, and he said, well, I've got a problem, Article X, Article Y. It was really, really very, very striking. But the bottom line of it was, basically, there has always been a strong strand of opinion in the United States that does not like the idea of international courts exercising jurisdiction either over Americans or in relation to US interests. But just to put this in a historic context, this has been the US position also on many treaties about international criminal law. So the first ever treaty on international criminal law was adopted in December 1948. It's a very famous treaty. It's the Convention on the Prevention and Punishment of Genocide. And the US signed the 1948 Convention on Genocide, but did not ratify it for 40 years. You might ask yourself, why was that? It was a similar concern that the concept of genocide might be used in relation to things that had happened in the United States in the treatment of indigenous communities, American Indians, or in the treatment of African Americans, Black Americans.
You're saying that the US didn't sign up to the Genocide Convention because it was worried about the possibility of being pursued for alleged crimes committed in the 19th century against Native American populations. Is that right?
Well, or even in the late 20th century in terms of lynchings in the United States and so on and so forth. I mean, to unpack that story, you go to Nuremberg. There were 4 prosecutors at Nuremberg, one for each of the Allied powers, the US, France, Britain, Soviet Union. And the 3 other countries all urged that the Nazis be convicted of genocide. But Robert Jackson, who was the US prosecutor, and he was on leave as a justice of the US Supreme Court, never mentions the word genocide and never supports the conviction of the Nazis for genocide because he comes under pressure from US Southern senators who are worried that the genocide concept is going to be used, particularly in relation to acts of lynching and other conduct and crimes committed against African Americans. So it's been a long-standing political issue. Could these crimes be used against us? And so they never ratified it until 40 years after the treaty was adopted. President Reagan made a visit to a cemetery in West Germany, placed some flowers on what he thought was an innocent grave, which turned out to be the grave of an SS officer. There was a great furore, and to quell the rebellion, they said, no, of course we are opposed to these kinds of acts and we will ratify the Genocide Convention.
So the United States was in at the ground floor, Philippe, at least 1 foot in and 1 foot out with this kind of contradictory thing where they've signed but not ratified. But how has the US posture to the court evolved since the days of Bill Clinton?
Well, I'd say it's been ebbs and flows. I mean, it's very, very peculiar. There's no constant position. They have not ratified it, so they're not parties to it, but that doesn't mean they haven't supported it. So in 2005, 2006, for example, the administration of President George W. Bush lent support to the ICC for its investigations of genocide in Sudan. And the support has come much more recently, even. When the International Criminal Court announced the indictment of President Putin of Russia, and Russia is not a party to the ICC statute, and so you may well ask, what jurisdiction do they have over Russian nationals? It comes back to what I explained at the beginning. Because Ukraine is subject to the jurisdiction of the ICC statute, any crime within the jurisdiction of the court that occurs on the territory of Ukraine, irrespective of who commits it, falls within the jurisdiction of the ICC. So if a Russian commits a war crime or crime against humanity in Ukraine, they're within the jurisdiction of the court. The US Senate did something remarkable. It voted 100 votes to 0 to support the efforts of the International Criminal Court. And then along come the indictments following the terrible events of October the 7th in Israel and the terrible events that have followed subsequently in Gaza. The indictment by the ICC prosecutor, supported by a panel of 3 judges of the International Criminal Court, of indictments of 3 Hamas-named individuals and 2 Israeli government-named individuals, including Benjamin Netanyahu. And at that point, the US goes ballistic. And so what you see with that, frankly, is an evident double standard. If you're indicting our opponents or our enemies, that's one thing, that's fine. But if you indict our friends or our supporters, that's a real problem.
And that brings us to what is happening right now, which is Marco Rubio, the US Secretary of State, writing this big long op-ed in the Wall Street Journal, sending out a press release to back it up, explaining why the US is, to use his words, dismantling the International Criminal Court, which comes down in the last paragraph of his article to the launching of a diplomatic campaign, essentially, is what he's calling for. It seems to be a pressure campaign, pressurising allies to adopt the US position towards the ICC. They promise they're going to do things like make diplomatic calls to other foreign nations, kind of encouraging them to take the position the US has. Or, and this is perhaps a threatening sentence, countries that enjoy the benefits of the US security umbrella, he says, are called upon to reject the ICC's purported authority to prosecute American officials and servicemen. And also this point about revoking visas and travel bans for ICC personnel. I suppose before we get into just what Marco Rubio is doing there, Philippe, would you be at risk of a sanction or a travel ban from the US State Department?
Who knows? I mean, who knows what their policies are? I may be, I may not be.
But if you look at Rubio's critiques of the ICC, Philippe, the word that keeps coming up is the word sovereignty. So if the United States isn't a signatory of the International Criminal Court Treaty, why should Americans be prosecuted in theory by the ICC? And likewise, Israel is not a signatory of the ICC. So why should Benjamin Netanyahu be prosecuted by the ICC? The United States would argue, and Israel would also argue, that they have their own functional legal systems that are doing their jobs, and to have a supranational court come in is a violation of their sovereignty. Isn't that a totally fair thing for them to argue?
The basic practice, the principle, is very straightforward. I'm a British national. I commit a crime in the United States. I am subject to the jurisdiction of US law. An American comes to the United Kingdom, commits a crime in the United Kingdom. In principle, they're subject to the jurisdiction of English law and of English courts. So a Russian who commits or allegedly commits a crime on the territory of Ukraine will be subject to Ukrainian law, and that law grants competence to the International Criminal Court. And that is just an established principle and an established practice. And it's not one that the United States, in other areas, has ever objected to.
I've heard officials say here in the US, and very much off the record, but that this is about somehow some kind of side deal, back-channeling element to a US-Iran deal, that the US is trying to undermine the ICC for Prime Minister Netanyahu because he does have that arrest warrant out for him and he can't travel to all of these countries, and that somehow all of this is interlinked and related to the strikes that the US has been carrying out inside Iran, which we still have very limited information on.
It may well be. I'm not privy to that information. I mean, one can see as a negotiating point, you adopt a very far-reaching position to bolster your negotiations, and then you roll back. We've seen it with tariffs, and so it could make sense. The real issue here is that I think Secretary of State Rubio's position is really about attacking the writ of international law more generally, beyond even the Netanyahu situation, and undermining, effectively putting within its sights, the 1945 moment.
I mean, if you look in what Marco Rubio is saying, he mentions Border Patrol agents working to remove what he calls violent criminals from our country. We know that there are massive deportations going on in the US at the moment. He says US Marines risking their lives to restore order in the Western Hemisphere. Presumably that's a nod to the removal of Nicolas Maduro from Venezuela. Do you think they are concerned, to your earlier point about Ukraine and Russia, that some of these US personnel who've been in other countries or have been involved with nationals of other countries, that they have an exposure?
Yes, I think they are worried. And I think, to be frank, they're right to be worried. I'm not involved in any of these issues, but I observe and I watch. And I notice, for example, the debate about the US targeting and killing people on boats in the Pacific and in the Caribbean who are alleged to be involved in drug running or drug smuggling or in some way with the narcotics trade. I think in the eyes of some people, that constitutes a crime against humanity. And if it involves territory or areas or perhaps countries which are parties to the statute of the International Criminal Court, then in theory, the issue is not just with border patrol agents, but it's with the Secretary of Defense, it's with the upper echelons of the military, it's perhaps even with the US president himself.
Marco Rubio has made this claim that the ICC is biased against the United States. But there is a case to be made, isn't there, from the other direction? There's been a critique for a while that the ICC only indicts and goes after black people from Africa, whether they're militia leaders or armed group leaders or even heads of state, and hasn't pursued enough people from Western nations. What do you make of that?
I've expressed that view because up until about 2022, it was the case that the only people who'd been indicted were from Africa and happened to be black. And people who are from Africa and are black do not have a monopoly on international criminality. I think that element of being conscious of sort of an imbalance in the work of the ICC has been there. I think people have been aware of that. But the idea that the ICC is biased against the United States or Britain or the West is really, I think, pretty unsustainable. How many cases are there against US nationals or British nationals? I'm not aware of any. There may be secret indictments, but I doubt it very much. But I think there are fair critiques to be mounted at how the ICC works. I don't think Mr. Rubio's critique is really on point, but certainly the ICC is not immune from criticism in how it has conducted itself over the last 25 years.
Marco Rubio also seems to take extreme issue with the people who are in the ICC. I mean, he has a sentence there where he says the ICC is backed and run by a powerful network of leftist non-government organizations, smug globalists, and hostile third world governments united by their enmity towards the US. What do you say to that? Do you consider yourself one of those smug globalists?
Well, I don't know. I don't know whether he considers me to be one of those people, but I personally don't. I mean, I'm a barrister. I act for all sorts of people. I've acted on cases, for the United States, against the United States, for Britain, against Britain. I personally don't think it's really helpful to start attacking lawyers or even entire countries in this ad hominem sort of way. I mean, at the English bar in particular, we act for all sorts of people. I think you both know that. Am I proud of all the people I've acted for over the years? No, I'm not. It's our principle of how we function. I mean, I'm in a curious situation, I'm married to an American. I have 3 American children. Why would I have an enmity toward the US? I teach at Harvard Law School. I visit the place. I love going there. I've been going there for 50 years. No, absolutely not. What I regret is that the country that has done so much for the rule of law that I care about seems, at least for this moment, to have taken its eye off the rule of law. And I'm not starry-eyed about the US role or the British role or the role of other countries. They've done some good things and they've done some not so good things. But basically, without the US, we wouldn't have this system of international criminal law that we have today.
Do you think his campaign can work then? Can the US dismantle the ICC, or does it carry on? Does it change? Does it outlast administrations?
I mean, time will tell, but my own sense is that what you're seeing here is actually expressions not of strength, but of weakness. And maybe 3 or 4 countries will say, gosh, it's too big a price to pay for our relations with the United States, and so we'll withdraw from the International Criminal Court. But my hunch is, no, this causes most other countries to double down, because at the end of the day, there is no country in the world that is more dependent on a system of international rules and treaties than the United States. Its well-being economically, its political strength has been constructed off a system of international treaties that it very largely played a lead role in elaborating. And I think over time that will come to be seen. Again, one of the things that made me smile was when I saw the memorandum between the US and Iran and the bit that dealt with the Straits of Hormuz. It is the United States that inserted respect for applicable rules of international law. Because ultimately, if you get rid of these rules, and that includes the rules of international criminal law, you undermine the system. And I think it's going to be the US, as much as anyone else, that will suffer from that.
Philippe Sands, thank you so much. It's been great to talk this through with you.
No, thank you very much for having me on.
Thank you for your time.
That was the international lawyer and writer Philippe Sands. And that's it for today's show. The Global Story is also an audio podcast. We're available on bbc.com or wherever you listen. Thanks very much for tuning in. We'll be back again tomorrow. Cheerio.